everyone here on the call. When Anirudh called me and requested me to act, I asked him whether we should focus on any specific area, as the topic is very wide, and I was not sure whether justice could be done in an hour's time with respect to the entire act. Well, he did ask me to make a presentation with respect to the overall framework of the Foreign Exchange Management Act from a litigator's perspective as well, because a number of the participants and attendees he mentioned were mostly litigators. So, from that context, I intend to just share my thoughts with respect to FEMA and the entire framework of FEMA from a bird's eye view, or for that matter, if we were to consider FEMA as an ocean, then it would be more of a snorkeler's view rather than a scuba diver's view. So we will be floating around. And, I would invite you to just share your thoughts in the form of Q&A, which we can, I think, discuss post the presentation, and let it be interactive thereafter, for all of us to just discuss and share thoughts. It might not be possible for me also to answer all of the questions. However, wherever I do not have the answer, or it's not possible because of paucity of time, I'll revert by circulating the answers to AKLC, who might share it with you. Can we just go ahead with the presentation? I'll just take you through the Kaushik can just move to the next slide. I think the overview which I would like to share today of the presentation, let's start with the legislative history of FEMA and the circumstances in which FEMA came to be legislated. Thereafter, the objects of FEMA as opposed to the earlier FERA can be discussed. The Act itself is a short Act, about 47-48 sections here. There are a few key concepts that we will go through, which we will understand in the context of FEMA, which terms you would have heard very often, but not necessarily applied to your mind in relation to the meaning thereof. So we'll just move to the next slide. So just to take us through the legislative history of FEMA. The legislative history of regulations or legislations dealing with foreign exchange can be traced back to the rules framed under the Defense of India Act 1939, insofar as foreign exchange is concerned. As far as independent India is concerned, the FERA 1947 was the first legislation to deal with foreign exchange control, followed by FERA 1973. Now, FERA 1973 was primarily enacted to conserve foreign exchange, prioritize investment in foreign exchange, you would have remembered the famous instances of IBM, Coca-Cola, etc., pulling out of India because of the various restrictions placed by the then existing FERA with respect to foreign exchange. However, with the 1991 liberalization efforts that were taken by the then government, and the foreign exchange reserves improving, and the focus becoming how to invite more foreign exchange and foreign investments into India, the Tarapur Committee was constituted in relation to trying to see whether capital account convertibility could be achieved. And there was a report submitted in the year 1997. Consequently, in 1999, the FEMA Foreign Exchange Management Act was enacted. We'll just go to the next slide. The objectives, as we just discussed, was that then it placed high restrictions in relation to dealing with foreign currency as well as securities in terms of inbound investments, outbound investments, etc. Then it also sought to regulate employment of foreign nationals in India, etc. But by 1999, since the Act had outlived its utility, a need was felt for a complete overhaul of the enactment, and a new legislation was passed in the form of FEMA in the year 1999, which came into effect from 1st June 2000. Next slide, please. Yeah, the problems that FEMA sought to overcome as against the old FERA was that the old FERA was a very punishment-oriented, criminalization-oriented legislation. A lot of powers vested in the hand, search and seizure, contraventions being met with imprisonment, and extreme controls with respect to all matters connected to foreign exchange. There were restrictions. The definition of authorized person was very narrow. The definition of resident of India was different from the Income Tax Act. So therefore, you could be a person resident in India for FERA, not necessarily for IT Act. So there was some element required for alignment. Then the penalties were high to the extent of almost 5 times the amount of the contravention. So these were all matters which caused a great level of discomfiture with respect to the business community. It sought to expand and take advantage of the liberalization norms that were introduced by the Narasimha Rao government. Next slide. So FEMA was legislated in order to consolidate and amend the laws in relation to foreign exchange and to facilitate an orderly development of a forex market in India, and then had a completely new approach with respect to how to deal with contraventions. In the sense that offences were made punishable with only penalties, and the only time imprisonment is considered is on a failure to make payment of the penalties within the time stipulated. So therefore, they were primarily made civil offences as opposed to criminal offences here, and the overall Act itself, there was a paradigm shift with respect to the old legislation which was there. Next slide, please. Some of the key features which, with respect to FEMA, that came about when the new Act was passed was that the powers of the central government and Reserve Bank of India have been clearly demarcated. With residency became the predominant basis for applicability of FEMA. Residency itself was based on citizenship under the old FERA. Also, foreign exchange transactions were classified into capital account and current account transactions. Each of these definitions we'll go into in a little bit more detail as we go along. And then there was a clear methodology mechanism that was specified with respect to both investigation and adjudication in the framework of the Act itself. And a new provision in relation to compounding of technical or minor offences, so to speak, was introduced in the Act itself under Section 15, along with rules in the form of compounding proceedings rules, which were also introduced, which we will also examine as we go along. So there was a light touch sought to be offered with respect to foreign exchange regulations. Emphasis being on encouraging inbound and outbound investments, and for foreign exchange to flow subject to certain restrictions of course time by the Reserve Bank of India through its various regulations. The overall regulatory framework in respect to foreign exchange, therefore, post FEMA, would broadly be looked at when you look at all of these regulations. That is, the Act, FEMA is there. Then there were Ministry of Rules and Guidelines which were issued by the Ministry of Finance in the form of Department of Economic Affairs and the Department of Revenue in the form of Consolidated Foreign Direct Investment Policy, which were issued from time to time. The FDI policy and the press notes were issued by Ministry of Commerce. The Department of Economic Affairs, of course, framed the rules that the central government was empowered to frame. The rules and regulations of RBI, which were framed pursuant to the powers granted to it under FEMA itself. Various notifications that were issued by the Reserve Bank of India, RBI also came up with circulars and clarifications as regards its rules and regulations. Until 2016, RBI used to consolidate its daily circulars from time to time in respect of a subject along the year, and in the month of July used to issue a master circular. Now, these master circulars from 2016 onwards, they were consolidated and issued in the form of master directions. Master circulars were restricted to a few policy-related issues. And master directions are issued by the Reserve Bank of India, which are updated from time to time. They are not issued once a year. The problem with the earlier master circulars used to be that if you take the master circular issued as of July 2019, RBI would have issued a number of relevant circulars relating to the subject from thereon until now, and you would not find it updated in the master circular. You would have to painstakingly look for each relevant circular as an update thereafter. So master directions were conceived of, which would get updated automatically with the issuance of the circulars or the amendment to the rules. Website, find a master direction which is usually updated, incorporating the latest change or a modification in either a circular or in any regulation, as the case may be. So that is a welcome move, and the master circular directions, there are about 17 or 18 master directions that are available on various subjects, which will give you a consolidated policy of the Reserve Bank of India with respect to that particular issue. Then FAQs are also available, issued by the Reserve Bank of India with respect to several issues where RBI feels that clarification is required in the form of a question-answer mode, whereby it's easy to read and understand for even the common man. So this is the overall regulatory framework which one would look for while trying to understand what is the legal position with respect to a particular area that concerns us in the matter of foreign exchange. We can just go to the next slide. Application issues for the purpose of amending various rules, repealing those rules and reissuing the rules. Several times the rules have been issued and reissued. For example, there used to be a regulation called the DIPP, the transfer or issue of securities by persons resident outside India regulations, which was issued, which dealt with basically foreign direct investment and other forms of inbound investment. Now that was issued and then reissued subsequently, and now completely replaced by new rules framed by the central government. We'll come to that. But notifications are the method by which they would make amendments, they would repeal old, issue new regulations, etc. Master directions, as I said, consolidates all rules, regulations, circulars, press releases on a particular subject from time to time and is updated on a real-time basis. FAQs are issued, circulars are also issued from time to time during the year. And it is also with respect to how the Reserve Bank of India regulates and legislates with respect to the foreign exchange control measures. The next slide, please. On the other hand, the central government also has the power to frame certain rules in relation to foreign exchange. In 2015, an amendment was introduced through the Finance Act 2015 to clearly demarcate the powers of central government and Reserve Bank of India with respect to rulemaking. Section 46 empowers the central government to frame rules in relation to what are called non-debt instruments. Section 47, RBI is authorized to frame rules in relation to debt instruments. So clearly, with respect to all debt-like instruments, which are the nature of loan, the Reserve Bank of India became the rulemaking authority. And under Section 46, the central government assumed for itself the power to frame rules in relation to non-debt instruments, which included all kinds of equity, then even LLP interest, and even acquisition of immovable properties defined as a non-debt instrument under the non-debt instruments rules. So basically, they began dealing with capital account transactions. An amendment was introduced to Section 6, which basically dealt with capital account transactions. whereby Section 6.2 enabled the Reserve Bank of India to specify the restrictions, the limitations associated with capital account transactions involving debt instruments. What is permissible, what is not permissible, such as external commercial borrowing, ECB as it's called, etc. While 6.2a enabled the central government to specify classes of capital account transactions that did not involve debt instruments, and therefore framed the non-debt instruments regulations rules which were issued in the year 2019 consequent to the amendment. Until then, the transfer of the RBI's transfer or issue. However, with effect from 2019, the new rules framed by the central government have since come into effect and today hold forth with respect to all inbound investment, with respect to non-debt instruments, including acquisition and dealing of immovable property in India by persons resident outside India. However, the central government arrogated to itself the power to define what are debt instruments and what are non-debt instruments. So, basically, by saying that debt instruments I will define, then it basically determines what are debt instruments and what are non-debt instruments, and therefore defines its own boundaries with respect to regulations that it can frame pursuant to Section 46. Next slide, please. So the central government, as we just discussed, exercises its powers under Section 6.2a and framed the non-debt instruments rules on 17th October 2019. And the non-debt instrument rules policy was issued from time to time by the Ministry of Commerce and Industry. And there was always, one had to look at the Reserve Bank of India regulations and then the FDI policy to understand whether or not a particular investment was allowed and what was the government's thinking and what is the Reserve Bank of India's thinking with respect to investments in that particular area. Now it has aligned, now that the central government has arrogated to itself the power to frame the non-debt instruments rules. Now there is a clear linkage between the FDI policy in the non-debt instrument rules itself, whereby the rules, any such non-debt instruments will have to be issued in accordance with the FDI policy issued by the central government from time to time. So there is some element of synchronization between the government and the Reserve Bank of India with respect to non-debt instruments post the issuance of the rules. Next. So the central government's power is basically exercised basically with the Department of Economic Affairs and the Department of Revenue. The Department of Economic Affairs frames the rules relating to the powers of the central government of the Act. As we saw, Section 46 gave it the power, along with regulation Section 6.2a. And pursuant to the power, it's the Department of Economic Affairs which were instrumental in the framing of the non-debt instruments rules in 2019. On the other hand, the Department of Revenue is responsible for the enforcement of the provisions of FEMA through the Enforcement Directorate. So we'll deal with the Enforcement Directorate. The Enforcement Directorate is basically an arm of the Department of Revenue and exercises the investigative powers and is responsible for the enforcement of the provisions and determination and prosecution of contraventions with respect to the provisions of FEMA. So these are the two arms of the Ministry of Finance which are associated with FEMA and its implementation. We also have deals with which is basically associated with FEMA. We can just go to the next slide, which is the Ministry of Industry and Commerce, acting through the DIPP, Department of Industrial Policy and Promotion, which operates as a nodal department for formulation of the FDI policy issued from time to time by the Ministry of Commerce and Industry. So every now and then the FDI policy gets, a consolidated FDI policy gets issued, sometimes every year, but say for the last couple of years a consolidated FDI policy has not been issued, and they have been covering it through issuance of periodic press notes, which operates as amendments and re-notification of policies with respect to a particular area of investment. So basically the Ministry of Commerce determines the policy, and as you noted in the non-debt instruments rules, any instrument has to keep in mind the FDI policy issued by the Ministry of Commerce foremost, filtering an investment to the suit the understanding between the company and the investor. So these have to be borne in mind. The consolidatory FDI policy was last issued, I think, in 2017-16. But since then, press notes have been issued from time to time, amending and modifying the FDI policy. Next page. So let's go to some key concepts, which terms we often hear of, and therefore this is just to familiarize everyone with these terms, which are used across FEMA, and which terms we need to understand for a proper appreciation of the provisions of FEMA and the various rules and regulations under it. The first and the most important concept is the concept of residency, and it basically deals with two classes of people: persons resident in India and persons resident outside India. So a person resident in India is basically a negative definition. A person who is not a person resident in India is a person resident outside India. And basically they deal with the various rights and obligations of these people to do various activities in and outside India under the regulation. We'll come to the definition, detailed definition of person resident in India as we go along, but I just wanted to put this concept on the table. Thereafter, it's non-resident Indian. So non-resident Indian is used from time to time across regulations, even the non-debt instrument rules it is used, primarily to mean a person who is not residing in India, but who is a citizen of India. Basically, he is a non-resident Indian. There are also other bodies, such as overseas corporate bodies, which used to be an important form of investment, but which was de-recognized as a concept in the year 2003, because these were being repatriation notes, etc. in those days, which masked the identity of the real investor. So these OCBs were essentially, as an investing class, treated separately besides NRIs, because of the fact that these were basically overseas entities in which at least 60% of the holding were basically comprising of Indians. So therefore, these entities masked, they were used and misused rather by incorporation outside India, in Mauritius or any other tax haven, for the purpose of making inbound investments in India. And it may often resulted in circular trading, had other issues of determining the source of financing, etc. So they de-recognized this concept of an OCP or a special status that was being accorded to OCPs to do certain things in India. And after 2003, any such entity which was registered outside India with even more than 60% was treated like any other person resident outside India. So there was no special that is outside India, or the assets and liabilities of persons resident outside India in India. So basically it deals with the balance sheet of a person in the form of either investments, loans, borrowings, acquisition of immovable property, sale of immovable property by persons resident in India outside, or vice versa. Basically those are all capital account transactions. While current account transaction is like basically it is an exclusive list. That is, it is a transaction other than a capital account transaction. It's a current account transaction. So basically, what is not a capital account transaction is a current account transaction from a FEMA perspective, and it also has an inclusive list, and those are clearly put beyond doubt as to whether or not these are current account transactions. And there are separate rules in the form of current account transaction rules, which FEMA regulates, RBI regulates these current account transactions. Another important thing is the concept of an authorized person, which was a very restricted entities were permitted to deal with foreign exchange. However, this definition was widened, and the class of persons who could deal with foreign exchange for various purposes, for disbursement, for receiving, for exchange, etc., was increased by defining authorized dealers, money changers, and there were different forms of regulations that were introduced for various classes of money changers, offshore banking units, etc., all of whom were permitted to deal with foreign exchange And therefore, while it was regulated, it was also opened up. It was unlike FERA. So again, we'll also look at the various classes of authorized persons as we go on. Next slide, please. So let's come to some of these definitions in detail. So I've just kind of prepared a table which basically defines who is this person resident outside India. So this person resident outside India means a person residing in India for 182 days, at least 182 days during the preceding financial year. So it is, which is stemmed in the concept of, residency and not a citizenship. So therefore, even a foreign citizen who is residing in India for more than 182 days during the preceding financial year can be considered to be a resident. But it does not include a person who is born outside India for employment or for business or for any other purpose which would indicate a stay outside India for an uncertain period. So even if I found a job, for instance, in the United States, by virtue of and I am employed there for an uncertain period, that is, it's not a tenure employment, etc. And even if my job keeps bringing me back into India for a period such that I don't satisfy the definition, I am not a resident in India. I am a person who is since I'm not a person resident in India, I will be a person in India for employment or business. That is, as I mentioned, talking about foreign citizens, etc., foreign nationals who have come to India for employment or for carrying on any business here, which would indicate a stay in India for an uncertain period, which is not a tenure or a period-oriented assignment or an employment. So they are persons who would still be categorized as persons resident in India and would be accorded all the benefits accorded to persons resident in India as is available under FEMA. The person resident in India is not only related to individuals. Wherever it wants to deal only with individuals, the Act and the regulations use the word resident individuals. This person resident in India, wherever it is used, also includes companies registered in India. Also, includes offices, branches, or agencies in India of persons resident outside India. If a foreign company has a local branch or an agency in India, that is a person resident in India. Like an office, branch, or agency outside India controlled by persons resident in India is also a person resident in India. So by deeming fiction, it treats these persons also as persons resident in India. Next slide, please. As we discussed, the person resident outside India is just a person who does not satisfy the above definition, and therefore he will be subject to various restrictions that the regulations impose. With respect to non-resident Indian, it's basically an individual residing outside India who's a citizen of India. You can remove the word OCA. OCA is being dealt with these days separately and not in the concept of non-resident Indian. In fact, most of the definitions basically defines commonly using the word individual who's residing outside India who is a citizen of India. He is only a person, he is only a non-resident Indian. Who is an OCI? Basically, OCIs are people who are registered and having a OCI card holder, are basically a OCI card holders under Section 7 of the Citizenship Act. So deemed to be OCIs now. It basically goes back to 4 generations. So if your father, grandfather, great-grandfather were Indian origin, then you are an overseas citizen of India who is eligible to apply for a card. So if you are a card holder alone, you are an OCI. It is the granting of that OCI card under the Citizenship Act which creates an OCI status for you. So who are the people who can apply? It's a spouse. Sorry for the typo. A spouse can apply for a card if the marriage is for more than 2 years. This is to avoid these marriage frauds. Then for former citizens, people who have since given up their citizens, like many NRIs in the United States who have since become, say, a US citizen, are eligible to apply and obtain OCI cards. Persons who are eligible to be citizens as of 26th January 2050, which is basically the Republic Day, all those persons are also eligible to become even though they are of our republic, to be a citizen of India. And people who belong to a territory that became a part of India after independence. So they are also eligible for OCI status. Next slide. PIOs, the concept of PIOs, which is now basically morphed into the OCI concept, is still used in some regulations associated with NRIs, which is basically similar to OCA but restricts itself to 3 generations. Basically, yourself, your father, your grandfather could be PIOs. Then spouse 2-year rule is not there with respect to PIO status. It includes an OCI cardholder to that extent it's circular in nature. And there are different versions of PIO definitions in different regulations. So there is some element of streamlining that may be required with respect to PIO definition itself as it is used in, say, a deposit regulation as opposed to, say, an acquisition and transfer of immovable property regulation. Bank of India working together to ensure that these definitions used across regulations are all streamlined and have a single meaning or an understanding. Next slide. Another concept which I wanted to just place before the group is basically what is called an LRS, which is becoming extremely popular now, and it gives avenues for a lot of people for use of these monies. Basically, it's a scheme framed under the current account transaction rules, which facilitates resident individuals to remit up to $250,000 per financial year for any permitted capital or current account transactions outside India. Basically, it's the total consolidated amount that you can use outside India, either for investment as a capital account transaction. As we discussed, what a capital account transaction is: for investment in property, investment in securities, giving guarantee, or funding in a house, for any such nature. While a current account transaction, for example, you're funding your foreign visits, sponsoring your children's education, etc. So these are all monies for which earlier one had to look for limits and approvals from the Reserve Bank of India to remit. To the fact that these are all permitted capital account or current account transactions, resident Indians can remit outside India by making a declaration in a form A2. Basically, it's typically no questions asked unless there is some other collateral investigation that goes on, and then they start going into whether or not you have actually invested it in accordance with the self-declaration that is made by you in Form A2. Otherwise, it's no questions asked. So now it's not available to corporates, partnership firms, trusts, HOs. It's basically available to individuals. It's also available to a family. For example, if it's a family of 4, investment, so long as each person satisfies this limit of $250,000. And for example, if they are going to invest $1 million outside India for buying a property, say in Soho or somewhere in New York, etc., if you want to invest $1 million, the limits apply to each individual, and those individuals' names should be found as co-owners, basically in the property or the security purchase. So long as that is complied with, this is a very useful facility that is available for resident individuals to basically invest outside India, even in mutual fund units, in the form of investment in securities, etc., shares for foreign companies, etc. Now, what are these permissible? When it says permissible capital account and permissible current account, basically examples of which I have just mentioned: private visits, overseas business trips, medical treatment outside India, which sometimes many people use Singapore for medical treatment, etc. Studies outside India, and it can be in any currency, in form of US dollars, 250,000. So the remittance itself can be in any currency. Permissible capital account basically deals with opening a foreign currency bank account abroad and depositing the money there for the purpose of purchase of property outside India, investment in securities outside India, setting up wholly owned subsidiaries or joint ventures outside India. So all of this through individuals. There is a separate regulation with respect to companies setting up wholly owned subsidiaries or joint ventures in the form of transfer or issue of foreign security regulations framed by the RBI, where a company is entitled to leverage to up to 400% of its net worth for the purpose of investment. That is, it can borrow up to 4 times of its net worth and invest outside India for the purpose of setting up any overseas entity without under the automatic rule. So basically, this is the ability for individuals themselves to set up subsidiaries outside India or joint ventures for the purpose of outside India. Next slide, please. So what does it not apply to? It does not apply to a foreign currency account in India. Basically, if you have an EFC account or an RFC account, and we'll come to this, what kind of foreign currency accounts can residents have in India? Basically, the LRS is not applicable. That means that you can use those monies freely outside India and you will not have utilized your limits under the LRS scheme. These are basically for remittance of rupee funds from India to an account outside India or directly for the intended purpose outside India for the purpose of usage for any permissible capital account or current account transaction. Over and above this $250,000, you have to seek the Reserve Bank of India permission. No restrictions on any number of remittances. You could just keep investing during the course of the year without any restrictions in terms of numbers, available even for minors. As I told you, a Form A2 declaration has to be made every time you are sending money outside India, availing of the LR, declaring the purpose for which you are investing, etc. And you have to provide your PAN details in relation to the same. Next slide. What are the prohibited activities? When we are talking about permissible transactions, there are also some prohibited transactions. Some of them are very obvious, but some of them you just have to bear in mind. Trading in foreign exchange is not permitted outside India. Lottery is not permitted. Foreign currency convertible bonds, which are basically instruments issued under a scheme formulated by the government for investment into India. That is to avoid circular trading. You can't go outside, purchase an instrument which basically is a foreign currency convertible bond, convertible into an Indian equity instrument. So that will amount to a circular trading. So that is not permitted. Remittances to certain countries which are identified as non-cooperative countries by the Financial Action Task Force is also not permitted. Funding terrorism is not permitted. So these are all restricted, but broadly, if you get the sense, it's a very open-ended for Indian residents who want to make investments outside or who want to spend monies outside India or use outside India. It's a healthy limit of about $250,000, which gets modified in times of need. RBI has often brought it down also, and then has also taken it. So it's $250,000 currently. The next slide, please. So what are these foreign currency accounts? What are the accounts which basically deal with, which can be held in India by residents? Apart from your savings bank account, these are all the foreign currency accounts that you can hold. Basically, there's an account called a resident foreign currency account that an Indian resident can hold, which is basically being a resident. These are typically opened by persons. They are basically available for people who, after long years of stay outside India, have moved back to India. They've sold their property, they've sold their securities, exercised their stock options. They've got a bunch truckload of money outside. They don't want to necessarily convert it into Indian rupees. They can hold it as foreign currency in the form of an RFC account. So it will be held in India in foreign currency itself for the use of these persons, because these were monies that were earned in foreign currency. Then resident foreign currency, the domestic account. Basically, that means that these are for people who are resident individuals who can have these accounts without even going abroad and earning this money and coming back to India. These are people who are receiving money from relatives from outside India, from the Oman and from any Middle East or anywhere else. If people are receiving and they don't want to hold it in Indian currency, they want to continue to hold it in foreign currency, this resident foreign currency account is available. And then there is an exchange earners foreign currency account, which is basically opened by residents who receive money in foreign currency out of that trading, out of the trading or any resident individuals. If you notice, First two concepts are basically resident individuals. EFC can basically be availed of by both individuals as well as corporates. It's basically, if you're earning foreign exchange outside India, you can hold it in foreign currency in the form of an EFC account, and money is used from these foreign currency accounts, if you remember, are not necessarily reckoned for the purpose of your LRS limits. That is as far as the first two accounts are concerned, because LRS itself is applicable only for resident individuals. Next slide. What are the accounts that non-residents can hold in India? You would also find this in these non-debt regulations, etc., in the form of, because money, these are all the accounts which non-residents can hold in the form of NRO accounts, NRE accounts, and there's something called FCNR accounts. So what is an NRO account? An NRO account is basically an account that can be opened with rupees earned in India or forex received from an Indian and person resident outside India. His account is automatically converted into an NRO account by the bank. So these monies can get utilized only in India, and there are some eligibility limits for taking out monies from these NRO accounts to overseas. And that is a form of a separate regulation. But basically, any money is lying in an NRO account can be utilized only in India, and for the purpose of any investment made by these people, or for other purpose, there is a reference to NRO accounts in all of these regulations, and treated as if they are monies coming from persons resident outside India. Then NRE account, they can be opened only by money received from abroad, unlike an NRO account which can be even with respect to rupees earned in India. And a rupee account that is opened by a non-resident from money received from abroad, it's basically freely repatriable outside India. Even the interest earned with respect to that income is free from income tax, and it can be maintained either as a savings account, FD account, or given the NRO account either as a savings account, FD, or a recurring deposit, any form of term deposit. It can only be, and the amounts are freely repatriable by these non-resident Indians. If they are earning higher interest in India as opposed to overseas, they can leave these monies in India in the form of a rupee account, earn the interest, and that interest is free from income tax here. It is freely repatriable outside India and held in an NRE account. There is an FCNR account, which basically are term deposits, available only in about 4 currencies, which are dollar, euro, yen, and pound sterling, and available for 1 to 3. These are options for non-resident Indians who are basically, as you remember, citizens of India who are residing outside India to still hold deposits in India through these various accounts, through NRO, NRE, and FCNR accounts. Next slide. So we'll come to this current account transaction rules. There are various current account. We have already seen what is the nature of these current account transaction rules. Basically, anything with specific inclusions that are mentioned there. Various regulations have been issued by RBI with respect to regulating current account transactions. The form of export and import of currency. There's a separate regulation called Foreign Exchange Management, Export and Import of Currency Regulation. Export and import of goods and services is also separately regulated by regulation. Insurance, current account transaction rules itself is there. Basically, all these are all regulations through which the Reserve Bank of India regulates current account transactions. Next slide. Let's go to the current account transaction rules itself. There are facilities available for residents, individuals, which we saw basically through the LRS, which is permitted, and also facilities for non-individuals. Some of the transactions require the prior permission of Reserve Bank of India, as there are typically threshold limits set. Some examples are like donations, 1% of the forex earnings outside which you want to make outside India, or 5 million, whichever is less. If you want to make it in excess of 1%, then you will have to basically get the RBI permission. Until then, you can make even overseas donations. Then contributions to technical bodies in the same field of activity as you, without even any limits. Commissions to real estate agents for the purpose of purchase of property or sale of property outside India. Then consultancy fees in excess of 1 million for other projects and 10 million for infra projects. Then remittance for incorporation, pre-incorporation expenses, pre-incorporation expenses, which exceeds the 5% of the value of the investment, or 500,000, whichever is more. So typically, these are all the limits above which you have to go and get the permission of the Reserve Bank of India. Otherwise, you can remit these monies by filing the necessary forms, and the regulations associated with these remittances are framed by the Reserve Bank of India. Next slide, please. Similarly, they also used to regulate all of the capital account transactions. Today, it regulates some capital account transactions except the non-debt instruments, for which the non-debt instruments rules have been framed by the central government. So they regulate it through these various regulations. I'm not going to read each of these regulations, but basically they broadly cover acquisition and transfer of immovable property outside India by residents and properties within India by non-residents, guarantees regulations both ways, where Indian residents are giving guarantees outside and overseas residents are giving guarantee for the liability here. Then non-debt regulations, basically with respect to equity instruments, immovable property acquisition, etc., which is all now consolidated into the FEMA non-debt instrument rules, which is framed by the central government. And the debt instruments regulations, which are framed by the Reserve Bank of India, is reissued. Earlier, it used to be dealing with external commercial borrowings, etc. To debt instruments. Now, Reserve Bank of India has reframed the same thing, the form of debt instrument regulations. Earlier, it used to be a regulation called permissible capital account transactions regulations. Now, it's because of this bifurcation between central government and RBI, two separate regulations have been framed. See, it's important with respect to FEMA not to know everything there is, every small regulation, because it's a very regulation and a circular driven. You have to keep going back, like Income Tax Act or any of the taxation legislation, to these regulations to see the current position, the current circular. So what is important is to understand the lay of the land, understand where you can find the law, and what exactly is the issue, what is the categorization under which you should bring it in, and therefore where should you look for. So essentially, I am only trying to show the path and where you must look for various regulations, because sometimes you get caught in a maze when you are confounded with the fact situation and you're not clear as to which is the appropriate regulation that you must look at. Because as there are Kaushik. Yeah. Then we come to the export of goods and services, basically which deals with the export trade is basically regulated by the Director General of Foreign Trade, that is the DGFT, who functions under the Ministry of Commerce and Industry and formulates the foreign trade policy. So these export transactions which have to be conducted in accordance with the foreign trade policy and the FEMA rules, which are basically the export of goods and services. So any exporter of either goods or services will have to basically keep in mind these regulations. There are some restrictions associated with realization of these export proceeds. So basically 9 months are given for entities, for all exporters, including units in SEZs, EOUs, software technology parks, etc., to realize the monies. Basically, the idea is that people should not use obligation that is placed to realize the monies, at least make best endeavors to realize the monies within 9 months for all exporters. And where goods are being warehoused outside India, they're giving an extended period of 15 months. And very detailed master directions have been issued in relation to exports of goods and services, setting out the process, form filing, etc., associated with export of goods and services. Next slide, please. Import is, however, they don't have a separate regulation. It's dealt with through master directions that are issued. The latest of which was issued in relation to that in January 27, 2020. That's the last update to this import of goods and services by residents from outside India. Import trade is also regulated by the DGFT under the Ministry of Commerce and Industry. And the authorization to manage these form filings and these imports are given to basically category 1 authorized dealers, basically which are banks. They have all imports of goods and services, any documents that are being run through them, and because all monies have to be transferred through these authorized dealers. have to be in conformity with the extant foreign trade policy as well as the FEMA rules and the master directions associated with that. So the banks are vested with authority to implement the regulation in the course of this import of goods and services. Next slide. The next one is also in relation to realization and repatriation of foreign exchange. That is, law requires that while it's fairly open with respect to inflow and outflow of foreign currency, it's not, India is not fully capital convertible, it's not fully achieved. Nevertheless, there's a very open dealing with our foreign exchange, both inbound and outbound, as we saw. But there is an onus that is placed which on a person resident outside, a person resident to basically realize the foreign exchange that has accrued to him outside India and repatriate the foreign exchange back to India. This is basically keeping in mind the need for India to augment its foreign exchange reserves. The exemption basically from this general obligation with respect to forex repatriation and realization is set out in a separate section, which is section 9 of the Act, and also codified, which is basically forex which is received before 8th July 1947. If you're wondering what's 8th July 1947, it's the date of notification of the earlier FERA, the first FERA, held outside India. It should not be outside India, outside India, pursuant to general or specific provisions. This is monies, forex, which are received and held outside India, pursuant to general or specific permission given by the given to the relevant persons at that point of time. They continue to be held outside India. They need not be repatriated. It's acquired through gift or inheritance from these people. Whoever has been holding it, if they have subsequently given a gift to you or you have inherited it from those people, you are allowed to continue to retain it. Then forex earned from employment, business, gift, inheritance, etc. to the extent permitted by Reserve Bank of India. And Reserve Bank of India also specifies through the rules as to other exceptions which may be which need not be repatriated to India, which has become due or has accrued to you outside India. So it's basically driven by the Reserve Bank of India to which tells you how much time you have and what monies you need to bring back to India if you earned it in foreign exchange outside. Next slide. So this one of the things, as we discussed in our, which was a difference from the old FERA. How much time do I have? Probably finish it in 10-15 minutes. Is regulation of authorized persons. Earlier, the categories of people who could deal with foreign exchange itself was limited. Broadly, I have just put a table with respect to the various categories. The first at the top, basically people who could have the maximum flexibility to deal with foreign exchange are basically the authorized dealers category 1. If you remember, authorized dealers category 1 are the people who also are vested with the responsibility of dealing with import of goods and services, and all form filing, everything has to go through them. They also have the maximum flexibility to deal with all current and capital account transactions, bills of exchange, opening of LCs, investments being routed through them, external commercial borrowings being made by entities through them, etc. So all of these happens through the authorized dealer category 1, which are typically commercial banks, state cooperative banks, urban cooperative banks, etc., who have got the category 1 license. Then category 2 authorized dealers are basically a one level higher, that is, it's called upgraded FFMC. FFMC means full-fledged money changers. So and there is an upgraded category that who, if they get a full-fledged money changer, can get upgraded or released. So these are all the persons who are permitted activities are all mentioned here, which are basically, they are permitted to deal with some specific non-trade related current account transactions which are permitted for FMCs, like medical treatment outside India for remittance, overseas education, visa, fees for with respect to prepaid cards, issuance of prepaid cards. All of these can be done by category 2 ADs. Then, next slide. There's also a category 3, which are basically entities which are permitted to deal with foreign exchange for their own business requirements. For example, Exim Bank, IFCI, SIDBI, these are all select financial institutions which have a different license, a sui generis license called Category 3 license. And then there are the money changers who basically licensed persons who are authorized to basically allow for purchase or sale of foreign exchange. You and I, when you are going abroad, when we FFMCs for the purpose of our visit and taking foreign exchange relation. So these are the various categories of people who are now authorized to deal with foreign exchange, but and facilitate the purchase and sale of foreign exchange in India. Next slide. Let's come to the contraventions and penalties. Section 13 basically deals with penalties and the powers to levy penalty for any contravention done up to 3 times the amount involved in the contravention. And you also have the power of confiscation under 13(2) with respect to either the foreign exchange which is involved in the contravention, or the foreign security, or this is in the form of a share. Suppose a share is issued in contravention of a certain provision of FEMA. Then the authority, the enforcement directorate can also, in exercise of its power, ultimately, if there is an adjudicating authority finds a contravention, then the adjudicating authority can order the confiscation of the foreign security for the purpose of realizing the penalties, etc. Then they also have the power of the IT authorities to recover the arrears of penalty. That is the when, because as you remember, the big marked change between FERA and FEMA is that FEMA is basically a penalty driven and not imprisonment driven. This thing, all contraventions result in a penalty, and imprisonment is only upon a failure to pay the penalty. Therefore, to recover besides imprisonment until they pay the penalty, they also have the powers under the IT Act for the purpose of recovery of the arrears of penalty. Next slide. Now, compounding. Now, this compounding was introduced under Section 15, which was not available under FERA, in order to reduce the load of the authorities to deal with contraventions of FEMA. And because it is penalty driven, it was found that wherever, except for certain offences which are certain contraventions which are not compoundable. What is not compoundable? If an amount is not quantifiable in respect of an offence, then you cannot compound that. This compounding proceedings rules sets out even the master directions is a very transparent direction which sets out even the metrics in terms of if there are offences of this nature, this is the compounding. So you have a very detailed metrics which is provided, which tells you basically what is the nature and the range in which the compounding fee will have to be paid. You will obviously have to arrest that offence. For compounding any offence or any contravention, you will have to arrest that contravention. You can't keep committing and be ready to pay the compounding fee from time to time. Then contravention, if you have committed, like other compounding statutes, if you have committed a previous contravention of a similar nature and you compounded that in 3 years, within 3 years, then you can't compound the next one. That is in order to ensure that you don't use these compounding regulations to be committing similar offences. Then if there are, once an order compounding is brought to the notice of an adjudicating authority until the contravention is decided, and then you bring to the notice the order of the compounding upon which you get discharged. But there are certain matters which are also not permitted to be compounded. If you look to the right hand box, matters relating to terror financing, money laundering, matters affecting interest, integrity and sovereignty of the nation will not be permitted to be compounded. In fact, if you are going for a disclosure suo moto, or if compounding, or there is a prosecution where you approach for compounding, you will be referred to ED for further investigation if ultimately there is found that this involves some element of terror financing, etc., or money laundering activity, etc. So these are not, except for these, other offences can be compounded with the Reserve Bank of India. Next slide. So what is the effect of this contravention on the underlying transaction? That is often a question. We recently dealt with one. I'm not going to discuss that case as the orders are pending. For example, in relation to the Kumudam case, where, for instance, the group of shareholders, and all of a sudden the minority shareholder, and that because it was in relation to press business, all of a sudden the minority shareholders passed a board resolution saying the entire holding held by this person, because the person had since become a non-resident Indian, stood cancelled as it is in violation of FEMA, and therefore claimed to be the 99% holder of the shares in relation to the company. That was the subject matter of challenge. Arguments were made, orders have been reserved. So that's about it. But this is the kind of a real life scenario in which where you would be considering what is the effect of a contravention in relation to an underlying transaction. This case, this came to be considered in the context of the Cruise City case versus Unitech in 2017, where it was in relation to a foreign award recognition enforcement which was sought to be objected to on the ground that it was violative of FEMA. That is, it was an exercise of a put option by a person on Unitech, which is an Indian company and a subsidiary, because of the fact that the project did not take off in India within a period of 2 years, and therefore they had the right to put their shares which they had invested in which will give them a return of 15%. So the objection that was taken was that this is a disguised debt, and therefore this is contrary to the then existing provisions of the transfer or issue of persons resident outside India regulations, because no equity instrument can be issued with an assured return. And therefore, it was attempted to be argued that this was contrary to FEMA. The argument, the respondents who were objecting to the enforcement also relied on the Renusagar's case decided by the Supreme Court, on the basis that there the court held that FERA constituted one of the fundamental policies of the land. And therefore, they sought to say that this would affect the fundamental for the award. The enforcement of the award would affect the area, but that argument did not find favor with the court on the basis that the court itself highlighted the difference between FERA and FEMA and the importance that FERA was in the context of then existing India, and how foreign exchange regulation was part of the fundamental, may have been part of the fundamental policy, but certainly not now in a free and liberalized economy. And the whole difference in the legislative policy between FERA and FEMA is worth reading. It is highlighted in para 103 of the judgment, and therefore the court said that it did not constitute sufficient ground, besides the fact that on facts itself they held that it was not a case of a guaranteed 15% return that arose only upon the non-meet satisfaction of a particular condition, which was that the project did not take off within 2 years of the investment, and therefore they had the right to exercise, and it was a matter of contract between the parties as to what is the rate of return and the damages that they should receive with respect to their investment. And therefore the court allowed for the recognition and enforcement of that foreign award. This was Cruise City. Next case, please. Then exploration versus so on. So there was a 2012 case where the Delhi High Court pointed out to the difference between FERA and FEMA, and basically pointed out that unlike FERA, which had specific provisions which were in the form of a negative proscription of certain activities, and therefore any activity contrary to that would be void, and which had resulted also in some penal provisions including imprisonment. They were considered to be mandatory, while FERA did not contain any provisions which voided the underlying transactions which were entered into in contravention thereof. So basically, while you have to still examine it on a case-to-case basis to understand the object of the legislation, mostly if mere contravention of FEMA will not avoid the underlying transaction, it may result in a contravention being adjudicated upon and a penalty being imposed, need not necessarily result in avoiding the entire transaction itself. Then POL projects was also a case of a guarantee regulation. Again, a recognition enforcement of a foreign award based on a guarantee which was argued to be contrary to the guarantees regulation and was therefore contrary to the fundamental policy of India, was again rejected. So the court's policies have been that FEMA does not constitute the fundamental policy of India, and any contraventions of FEMA, if found by an arbitrator, or even if it's not found by an arbitrator when an award is passed, can be a ground for either setting aside of the award or for the purpose of non-recognition or enforcement of the foreign award. That plea has been consistently rejected by the courts. Next slide, please. So let's go and just understand the adjudication process, which is basically the bulk of FEMA, because these rules have been, this this thing has been specified in detail. And there are also rules framed in the form of adjudicating proceedings and rules and appeals rules. Basically, there is an adjudication authority who is appointed by the central government, and any contravention, the wheels of the law, the adjudicating process are commenced by a complaint filed by an officer authorized by the central government. So even if a person wrote to the Enforcement Directorate or the Reserve Bank of India with a complaint that somebody else is engaged in a contravention, these authorized officers will examine prima facie, conduct some preliminary inquiry, and only upon then they find that if they believe that there is a contravention, that they will file a complaint with an adjudicating authority for the purpose of adjudication of those complaints and for imposition of penalty. It's a quasi-judicial process. An opportunity is given to the accused in respect to against whom the contravention is alleged. Show cause notice is issued as to why the inquiry should not be held. So, in initial show cause notice is issued, a 10-day time period is given. Adjudicating authority can decide based on the reply as to whether or not further steps in the inquiry should go on or not. Next slide, please. It might choose to close if it is satisfied with the show, and at this stage, the accused can take the legal assistance and representation, and be also offered the opportunity of filing its written explanation along with whatever documents that it finds are relevant. And finally, it results in a finding of either that the contravention is committed or not. If the contravention is committed, there will be a penalty imposed, and the penalty is to be paid in 90 days. As I mentioned earlier, the civil imprisonment will only arise if the penalty is not paid. Normally, a period of 6 months of imprisonment is granted, up to 6 months if the penalty is less than 1 crore, up to 3 years if the penalty exceeds 1 crore. However, if the penalty is paid, you are entitled to be released. Next slide. Then appeals from the orders of the adjudicating authority. If the adjudicating authority is in the rank of an assistant director or a deputy director of enforcement, goes to a special director appeals, and appeal is to be filed or receipt of the order copy. That's under section 17, and the rules associated with how the appeal process should be conducted are all available in the adjudicating process and appeals rules. Similarly, under 19, there is a further appellate authority as well as an original appellate authority with respect to some orders passed by adjudicating authorities other than these people, or from the orders of the special director appeals within 45 days of the respective orders. There is a precondition before the appellate tribunal that the penalty determined by the adjudicating authority has to be deposited with the discretion available, just like the DRAT. Discretion is available with respect to dispense with the deposit of the penalty. There is no bottom limit, depending on the hardship of the person. Section 35 provides for an appeal to the High Court on a question of law within 60 days from the order. Next slide. Now let's come to the other arm. This is the adjudication process. The investigating arm is, is the Directorate of Enforcement, or the ED, which was originally set up in 1956 and is responsible for basically the enforcement of FEMA and certain provisions of the PMLA also. There are 10 zonal offices, and there are also some sub-zonal offices. There are 11 sub-zonal offices underneath these 10 zonal offices, basically, which are branches of ED across the country. Next slide. Investigation of suspected violations. What is the function of the ED? They investigate into suspected violations of FEMA. That includes, it could be hawala transactions, purchase of assets abroad, possession of foreign currency, non-repatriation of foreign exchange, non-realization of export, any of the violations of any of the regulations that we just looked at during the last 1 hour. Also, they collect, develop, disseminate intelligence information with other central and state government authorities. Then there is an attachment. They have the power of attachment of assets. Persons found guilty of FEMA violation against the offences under PMLA. Settlement of cases also with respect to violation of FEMA, and to decide penalties upon conclusion of settlement proceedings. Next slide. So the FEMA basically empowers the director and the assistant director of the ED to exercise the power of investigation. They are given the same powers as IT authorities. There's a judgment of 2006 AR 2006 Delhi, which basically dealt with the power of ED with respect to impounding of passport. It was argued in that case before the Delhi High Court as that when the ED attempted to impound the passport of a person for in relation to certain contravention, it was argued that the impoundment of passport is not available under section 37(3) of FEMA, basically which 37(3) only said, I have the power of IT department, IT authorities with respect to search and seizure, and 131 a document. You can seize any document. So the question arose as to whether a passport is a document, and whether the authority under the Passports Act alone is the authority which can exercise the power for impounding. The courts came to the conclusion that there need, and they had also argued there need to be underlying proceedings, without which an impoundment of passport cannot be done under section 131, because that's the power of the IT authority. The court said that in the context of ED, there need not be any proceeding because this power of an IT authority in the course of proceeding has been granted to an ED in the course of investigation. So there need not be any proceeding for an impounding of passport. The power under 10(3) available with the passport authorities is not exhaustive. The ED has the powers of the civil court with respect to discovery, inspection, compelling attendance of persons, production of documents, issuance of commission. And the word document for the purpose of 131 includes a passport and therefore confirmed the ability of an ED to also impound the passport of any person, and said that often it would involve offences outside India, and not having the power to impound the passport and having to follow the procedure of the Passports Act would be an impediment for the ED to conduct such investigations. If the person are allowed to go outside India, there is a possibility of any tampering of evidence, etc. Then another case which might be worth looking at is the 2010 judgment of Justice Chandru in K. Mansoor versus Assistant Director, Enforcement Directorate, where summons issued for the purpose of attendance under section 37 was challenged by way of a writ petition on the ground that that summons was issued without application of mind and would amount to a roving inquiry. The court dismissed that writ petition on the ground that in that case no excess of jurisdiction, that is, it was not contested that summons cannot be issued by the authority, or he did not challenge the provisions under which the summons are being issued. In the absence of that, it would amount to a prohibition, writ of prohibition, and therefore purpose of investigation cannot be the subject matter of a writ petition, and therefore dismiss the writ petition. Next slide. Unlike adjudicating authority, at the time of recording a statement by the ED in the course of investigation, an accused or a person who is called upon this thing does not have a right of legal representation. If he does not appear before the authority, actions can be taken to summon the presence of the relevant person, and also be prosecuted for a contravention of failure to attend itself is a contravention and can be prosecuted using the adjudication process. So these are all the powers of the Enforcement Directorate, and you see the ED is omnipresent with respect to so many high-profile litigations, and they have very wide powers, which are akin to those powers available to an income tax authority with respect to investigation. So I've covered investigation, adjudication, as well as the during the time that is available to me, and I'm available to take any questions associated with this from the participants. Thank you.
Thank you very much, sir, for a very, very informative.
Kaushik?
So the first question is, after passage of Finance Act 2017 and subsequent merger of Appellate Tribunal with Smugglers Tribunal, is there any substantial difference in function of the tribunal?
No, the powers of the appellate tribunal, FEMA, there is no substantial change with respect to the powers of the appellate tribunal, which is constituted pursuant to the provisions of FEMA, and the tribunal may also, just like the NCLT functions both as an adjudicating authority for the NCLT, for the IBC, as well as for the purpose of deciding various decisions with respect to the Companies Act. The same authority may be granted powers under a different statute, but its powers vis-a-vis dealing with contraventions and appeals against orders of adjudicating authority or special director appeals remains the same and prescribed by the Act itself.
Mr. Saravanan Kumar has asked another question. When someone has declared certain amount under capital account transactions to RBI, does the same statement can the same statement be used against him by income tax authorities in calculating income?
See, as you are aware, the investigative agencies, that is like the Enforcement Directorate, they share with several other state and central government authorities. So, if you have made a declaration or a statement as to the status or the nature of a transaction, that statement can be put against you by any other authority for the purpose of that particular enactment. So, if you have treated a particular asset seen as a capital account transaction, then you cannot claim it as a particular expenditure and you cannot seek to write it off before income tax authority. It will have to be treated as an asset, a capital asset, for the purpose of Income Tax Act also. So it could be used by the income tax authority, but it has to be decided on a case-to-case basis.
There's a question from Mr. Karthik. In some scenarios, FAQs state more than what we can find in any circular or directions. Can we take FAQs to be the basis of an action or omission? Or would it in some form be informal guidance given by some other regulators like SEBI that does not necessarily bind the board?
Yeah. These FAQs don't have any statutory force on record. Even for the informal guidance of SEBI, there is a basis, the form of of an underlying regulation pursuant which the SEBI issues informal guidance, which it issues subject to so many caveats. It has no binding precedential value, plus it is only applicable to the facts of that case. But as far as an FAQ, it is usually issued agnostic to any fact situation. However, if it goes beyond a mere explanation or a clarification of an existing rule, then that can be a subject matter of a challenge. Because it is not covered, it's not a subordinate legislation.
The next question is from Ms. Revati Muralidharan. Should a person whose status has changed from resident to non-resident, should they intimate the AD upon change of the residential status?
There is no obligation to intimate, though your account nature changes to NRO account. There is when your status changes by the fact 2 days, the onus is on you to acknowledge your change in status and act as a non-resident. There is no specific provision which requires you to intimate to an AD or your banker or anybody to specifically change. The nature of your bank account is deemed to change to an NRO account. Therefore, the spend associated with that is also the same nature as an NRO account. So while there is no obligation, you can intimate in order for the bank to classify, but there is no obligation. You have to take into account that you are an NRI and act accordingly. And any manner in which you think you are a resident and you act as a resident may result in a contravention.
The next question is from Ms. Aishwarya. Can an Indian party directly fund step-down subsidiaries?
Can an Indian party
directly fund step-down subsidiaries?
You mean outside India?
That is not clear, sir, in the question.
Means is an Indian party has invested into a subsidiary, wholly owned subsidiary outside India and a step-down subsidiary. There are regulations associated with it. I don't want to go very specific. There are regulations and master directions associated with overseas direct investments. Kindly take a look.
The next question is from Mr. Srikanth. Is it now open to an international arbitrator to rule on matters that might have FEMA implications?
It is open. Yeah, Srikanth, it is open for, see, if an arbitrator, an international arbitrator, or let me say an arbitrator in an international commercial arbitration, either having its seat in India or outside India, whether it is a domestic award or a foreign award, will rule according to the governing law of governing the contract. And if it incidentally has, if it is according to Indian law, he should take into Indian regulation which is applicable to the contract. He may deal with it in the context of a foreign law, agnostic to a domestic Indian FEMA regulation. It could have an implication, in which case an award can be passed, and if you go by some of these decisions, the recognition and enforcement of the award may also not be challengeable on the basis that it affects the fundamental policy of India. Yet, at the time of even these very cases, recognize that when the money is sought to be taken out, it can still be put that the taking out of the money by way of enforcement of the award would violate some FEMA regulation, and objections could be raised in relation to that. So, yes, it may have, they could still pass an award which has FEMA implications, but if money is to be paid out on the basis of that, there could still be objections that such money is have to be paid out contrary to FEMA. I think in the context of this Tata Docomo, some of these issues had arisen. RBI.
The next question is from Revant Charan. If a person decides to invest more than 250,000 USD abroad on a business, how can that be made legal as per LRS?
As per? Where is that?
LRS.
So, person, if it's a contravention, see, first of all, the resident individual can invest up to 250,000 under the LRS scheme. To invest more than 250,000 in a financial year will require RBI permission. So, if I have declared and I have gone ahead and utilized or remitted outside India amounts more than 250,000, it is a FEMA contravention. I have to compound it.
That's also
right. I think. Thank you, AKLC and Kaushik and Goda and Anirudh for giving me this opportunity to share my thought to FEMA on any specific area by through a 1-hour presentation. But I'm happy at least I got to discuss the overall framework of the Act. And at a further time when we start dealing with specific topics, we can always get into the details. Thank you.
Yeah. Thank you, sir. Thanks for sharing your time.